Well, good morning, everyone. Thanks for joining us this morning. Donal, if I can ask you for the next slide. Yeah, thanks for joining us this morning. We're going to be discussing in detail the latest consultation on ending one-sided flexibility and the Employment Rights Act. For those of you who don't know me, I work within the hospitality and leisure team at Moore Kingston Smith, providing strategic people services to a large number of our hospitality businesses. My background is hospitality, having worked in senior people director roles at Big Table Group, Flatiron and Aqua Restaurant Group. I'm joined this morning by Donal Moon from our employment law team at Moore SGD Law and David Sheen from UK Hospitality. Guys, if I can ask you both to introduce yourselves for the audience.
Thank you, Claire. Good morning, everybody. My name's Donal Moon. I'm an employment law solicitor with Moore SGD Law. I only recently moved to the team and resumed practice as a solicitor. Prior to that, I've spent 14 happy years with MKS in the HR consultancy. But my focus throughout has been keeping clients on the legal straight and narrow and up to date with all of the challenges that they can expect on an employment law front at the moment. So hopefully today will be interesting for the audience.
Thanks, Donal. Morning, everyone, and thanks to MKS for having me on today. Looking forward to it. I'm David Sheen. I'm our Public Affairs Director at UK Hospitality, which, as I'm sure many of you know, is the trade association for the sector. We've been very, very heavily involved in the employment rights process, probably way back since pre-election when Labour weren't in government. So just here to give a sort of top level overview of where we think that the sector is in terms of employment rights changes.
Thank you, David and Donal. Donal, next slide, please. So running very, very quickly through the agenda, we've got a lot to cover this morning. We'll be hearing from David, as he said, with a view on the consultation and overall insight from UKH. I'll be covering off what the consultation is actually asking, and Donal will cover off Employment Rights Act, and then we'll discuss very briefly single-sex spaces and the data protection changes. So this is being recorded, so colleagues who are missing from here, or if you have to leave early, you will get a copy of the recording along with the slides. There is a Q&A button to be able to ask questions. So it's usually at the top of the screen or at the bottom. So please do post your questions there. And we have allowed time at the end, but as I've said, we've got a load to loads to cover off this morning. So if we don't get through to answer any of the questions or not all of them, we will send out an anonymous Q&A by the end of this week for you to all have the answers. So Donal, if I can have the next slide, please. Thank you. So these are the new rights relating to one-sided flexibility. It's worth remembering that this is now law in the statute books and is definitely going to happen in 2027 as part of the Employment Rights Act. So it's broken down to three elements: the right to be offered guaranteed hours, reasonable notice, and compensation. Next slide, please, Donal. And it goes without saying the impact that it will have on our industry. We are such an agile and nimble industry and don't relish another set of regulations for managers to have to track. How are we expected to deliver excellent guest experience that make our sector so unique? So for the view from UKH, I'll hand you over to David. Next slide, Donal. Thank you.
Thanks, Claire. And I'll just sort of take it up a step before we come back down. But I think from our perspective at UK Hospitality, as I said, we've been engaged with government on the employment rights piece for a long time, and it's good to see that we're getting to the stage where we're starting to see some of the detail. Part of our role is obviously putting all of this in context for government. The Employment Rights Act itself is huge. but it also needs to be seen in the context of all the other challenges that the sector's facing. We all know the wage cost pressures through national and living wage increases that we've seen, obviously employer NICs. All of that's making it harder to employ people in the sector. So that's a conversation that we're constantly having with government. We're in the process of working with the Low Pay Commission on what minimum wage rates look like for 2027. Clearly, that's going to play a part. And then there's obviously the tax landscape. We saw big changes in business rates from April this year, which have seen increases for most businesses. Government has been proposing the introduction of what we've dubbed a holiday tax in England, which already is in place in Wales and Scotland, which is a levy on overnight stays for accommodation businesses. And then sort of the big cost and the big lever that government could pull around VAT. Hopefully people will have seen the campaign that we're supporting, spearheaded by Tom Kerridge, called That's the Problem. An excellent attempt at a pun. We've sort of soft launched that to industry to build industry support. We launched it collectively with our partner bodies on the 1st of June, I believe, 8 days ago. And so far we've had 183,000 petition signatories. So I think that shows the groundswell of support in that area. And that's something we're going to continue to push with Tom, with others, to try and get government to make that change. Whether we see something in the short term on VAT, we hope we do. But it's a campaign that is pushing the message that this is a sector that's under strain and needs support, and VAT is the ultimate answer to that. Talking about all those pressures, I still think we have the advantage that government, certainly parts of government, sees us as a solution. We are the answer to youth unemployment, which is one of the big strategic challenges the government faces. We know, we've seen all the data around 1 million NEETs. The Milburn Review talks about how we challenge that, specifically called out hospitality as a solution for first-time jobs, entry into the market, return into the market. So we think we've got a real opportunity there, as well as sort of the broader high street regeneration, economic growth, social mobility, all the good things that our sector does. So we're continuing to make those points. Coming back down to the Employment Rights Act, I'm not going to talk into any detail because we've got experts here from MKS who are going to do that. But again, just to re-emphasise, the whole Employment Rights Act is huge. It's 27, 28 bits of legislation. All of those will have an impact to a greater or lesser degree on hospitality, and it will have significant impact on operations. Some of it's quite hard to anticipate exactly what will happen. The trade union legislation could be very, very difficult to deal with, but that sort of depends on how much resource the trade unions have. As I mentioned, we've been really engaged, and we engaged with Labour before the election. We obviously saw their manifesto pledges around this. They were pretty stringent, I think it's fair to say, banning exploitative 0 hours contracts, unfair dismissal was a day one right. We have seen quite a lot of rowing back since they've got into government. We've had to talk to the officials who have been tasked with implementing this in law, and gone, come on guys, some of this, it really isn't actually feasible. We need to be much more practical, and I think we've seen quite a lot of that. And again, Claire's going to come into some of the recent consultations, but I think there's a lot more wriggle room than we originally envisaged. Although saying that, my ultimate summary of this is it's not as bad as it could have been. However, it is still going to be very challenging for businesses. So this is going to see fundamental change. And to be fair to government, they will say, yes, that is true. We want fundamental change. We think the market is slightly broken. We think there is one-sided flexibility, and we want to see change. Again, our job is to push back and highlight the practicalities and what the unforeseen consequences are of doing that, in terms of closing down the job market, providing less flexibility to our employees. And yeah, again, building on our role, we are continuing to battle through all of these consultations. I think we've probably responded to about 15, 20 over the last 6 months on various issues. I do think the ones that Claire's going to talk about are going to be the most consequential for the sector. But ourselves, working with partners like MKS, have got and indeed with the entire hospitality business community, have got a role to shape what comes out of this at the other end. And being glass half full, I think there's a lot still up for grabs. But I think we've got to make sure our voice is heard loud and clear, and we'll be doing that obviously through UK Hospitality. MKS will be doing their part, but ultimately I think we need as many voices into government as possible. So it'd be great if businesses on this call will also be responding to some of the consultations. We'll be putting out template responses that we think capture the mood of the industry, but sometimes it's a bit of a numbers game, and the more businesses that government hears from, the better. So that's sort of my top line summary. So I'll pass back to you, Claire.
Thank you, David. I'm really grateful for you to giving up your time this morning, because I know you're very, very busy. So Donal, if you can share the next slide. So this is what the consultation on ending one-sided flexibility actually looks like. It's available on the government website. It's open until the 25th of August 2026. And there's a link. So when you get the slides back later on today or by the end of this week, you'll be able to click on that link and go straight to the consultation. Next slide, please, Donal. So let me start first with probably the most significant element of the consultation is the right to guaranteed hours. So in simple terms, the government is proposing that if someone is regularly working a pattern of hours, we will need to formally recognise that in their contract. So when a team member is working broadly consistent hours over a reference period, and that reference period the government would prefer to be 12 weeks, we would be required to offer them a contract that reflects that reality. So this shifts responsibility quite clearly onto the employer. We'll need to actively track working patterns, regularly assess who qualifies, and then proactively offer a more stable contract. In hospitality terms, this is really about those hidden full-timers or people on 0 hours contracts, but in reality are probably working 30, 35 or even 40 hours a week. And going forward, these arrangements become much harder to justify. So this isn't about removing flexibility entirely, but it does mean that we can't rely on long-term variable contracts for roles that are actually quite stable. Next slide, please, Donal. So what sits underneath this is a much bigger shift in principle, and this slide is actually taken from the consultation document. So it talks about people being in scope and workers having to qualify. It's also worth noting at this point that when we talk about workers, we are going to be talking about directly employed workers, but this legislation is also covering agency workers. So historically, the flexibility in hospitality has largely sat with the employer. We flex labour up and down to match the demand. What the government is trying to do here is rebalance that. And that's the theme that's going to run through all of these measures. Next slide, please, Donal. Again, another extraction from the consultation. So we rely very, very heavily on flexible labour models. And that's good, for good reason. Our demand is unpredictable, it changes daily, particularly in the British summertime, and often at very, very short notice. But what tends to happen over time is some of those flexible roles stop being truly flexible. So, for example, a bar supervisor who ends up working full-time hours across their entire summer season, but stays on a 0 hour contract. what the government is saying is where that pattern exists, the contract should reflect it. Next slide, please, Donal. Okay, so question 1 on the consultation document, and don't worry, we're not going to go, we don't unfortunately have time to go through all 56 questions, A's and B's. So already we're hit with, probably, there are a very few number of really important questions on the consultation, this being one of them. We're already being asked what our views on low hours are. The government have set the bar at 8 hours a week. So if that goes through, everyone on 8 hours or less will be covered by these regulations. So you have the option to state a figure lower than 8 hours, which might be necessary for your business. And as with any good exam paper, there's always a please show your workings and please explain your answers. Next slide, please, Donal. This is a real sticking point, the reference period. So question 4 of the consultation. So say, for example, this comes into play in, I don't know, say January 2027. 12-week reference period would include Christmas hours, which historically go up over that period. Or, 12-week reference period, say in 2020, in April 27, would be beneficial for employers as sales and hours drop. So where's the win for the employees? And that's really the theme that runs through all of these measures. Why not a 52-week reference period, which will include the peaks or troughs? And a contract should be aligning more closely with the reality. Next slide, please, Donal. The next sticking point. So how many times should we be offering these guaranteed hours? Once every 12 weeks? Once a year? Is every 12 weeks having to reassess and look at people's hours? Is that going to be workable in the new world? Surely, once a year should be more sensible. But it is worth remembering the words. So a right to be offered a guaranteed hours contract. Many of our staff, as we know, like the low hours. They like 0-hour contracts. They like the flexibility that this gives them. People, parents or carers or part-time working. So it may be that these employees do turn these offers down. And of course, we will have to monitor it and we will have to prove that this has been offered every 12 weeks. It becomes a logistical and a paper absolute nightmare. So I don't believe, and I'm sure everybody else would agree with me, that 12 weeks isn't workable. Let's have a more sensible timeline. Next slide, please, Donal. So this particular part of the consultation gave me GCSE maths exam vibes, I have to say. I can't remember looking at means or medians for a long time. So the government, again, is asking what would be a better average, the mean or the median. So my advice to you is to be working this out now. So have lots of examples in front of you to be able to work out which is going to be the better, which is going to work out better for your business. Donal, next slide, please. Thank you. The next major change is around the right to reasonable notice of shifts. So workers need to receive advance notice of their shifts and any changes to them. Now, one of the big unanswered questions in the world is, what does reasonable actually mean? What I think is reasonable might not be reasonable to anybody else on this call. And will this vary by sector? There are options on the consultation. Currently, it's not unusual for rotas to be published just a few days in advance, or changes even to be made the night before when we look at the ever-changing weather, or you get a large booking that suddenly cancels at the last minute. In future, these practices are likely to come under pressure. Next slide, please, Donal. In practical terms, this could mean the end of a lot of what we consider on-call style working. Less same day or next day changes, and a shift towards publishing rotas further in advance, which will mean we will have to rely much more heavily on accurate forecasting. So, question for everybody really before we go into 2027 is, how good is your forecasting tech? Are you using tech to regularly forecast and regularly decide your rotas? Again, the government are asking about the numbers of hours per week that would make an employee eligible for reasonable notice, and this would also apply to consultation. So you can see that the government are really asking a lot of detailed questions, and as David said, we would urge every operator to engage with this consultation, because the lower hours means less people will be covered into this threshold. If we all said the threshold for reasonable notice and short notice payment was 48 hours, that would mean everybody in your workforce would be covered. Next slide, please, Donal. This creates a real operational challenge, because our demand, as we know, isn't perfectly predictable. A sudden drop in covers, a cancelled booking, bad weather, all of these things currently drive last minute decisions. And again, this slide is taken directly from the consultation. And they talk about, the Living Wage Foundation, they talk about the CIPD. They don't quote UK Hospitality, for example, in this part. Under these proposals, these decisions are going to have to come much, much harder to deliver without consequences. Next slide, please, Donal. As I said before, reasonableness means a lot of things to a lot of people, but what is flexible and workable for each individual and each operator on this call? How workable is it to provide their teams with their rotas, 1 week, 2 week, 3 week, 4 weeks in advance? And again, please do show you're working. You also have the option to tick 1 day in advance if you want to. Next slide, please, Donal. The third element is probably the most commercially significant in the long term, and that's the right to compensation. Now, we know workers would be entitled to payment if shifts are cancelled, shortened, or moved at short notice. So where today we might stand someone down early or cancel a shift due to low demand, in future that could come with a direct cost. And the exact level of compensation is still being consulted on. So this is where labour stops being that fully variable cost. So inefficient planning becomes visible and measurable in cost terms. Next slide, please, Donal. So what is our definition of short notice? Would you consider 2 days, 1 day? We can't say it enough, but we know that the unions are going to be feeding into this consultation, and will most likely be going with the largest figure. So we get the choice of short notice, and Donal, next slide. We get the question, what's very short notice? So we do have the option of less than 1 day, but again, we need to specify, 1 hour, 2 hours, 3 hours. Next slide, please, Donal. And in hospitality, there's a lot of plenty real world scenarios where this could land. We know weather impacting outdoor trade, group bookings, as we've already said, cancelling late. We overestimate demand. And in the future, these may result in additional cost instead of simply flexing the labour down. Next slide, please, Donal. So we've got some live options about the right to compensation and how much compensation is to be considered. Again, another GCSE maths paper just shouting right there. So we have options. So again, to reiterate, this is taken directly from the consultation document. Are we saying a percentage of what the worker would have earned from working the shift, or a percentage of what the worker would have earned from working the shift at national living or minimum wage rate? So we do have the options to be feeding into this. Next slide, please, Donal. And then we need to work out the percentages. Of course, all of this will have to be programmed into payroll and HR systems to be able to calculate this. So again, to reiterate my earlier point, please start working on some practical examples on how you perceive some of these options will affect your business. Next slide, please, Donal. Again, we're looking at percentages, and we get to input on some of this. So question 50A. So you've gone from question 1 through to 50, and we're still not at the end of the consultation. Next slide, please, Donal. So Donal will cover off the Fair Work Agency shortly, but the government are even asking about enforcement, and should the Fair Work Agency enforce the right to short notice payments, and impose penalties, and what should that take the form of? So again, we have free rein to be talking about this, answering this, engaging with this. Next slide, please, Donal. And we also get the penalty amounts. So we get the option to say how much any fine should be. And again, to reiterate the point about the unions will be fully engaged with this, fully committed to answering all of this. So again, reiterate the importance of actually answering this. Next slide. So that was a real whistle stop. We could spend all morning on going through the consultation question by question, but I've just taken out some real key, really important questions. You don't have to go through the consultation document and answer every single question. Particularly, it's repeated a lot on the agency workers, but please do answer as many questions as you can. As I said, we get the option to define what qualifies 0 hours versus low hours, the rules of the reference periods, how often we need to reassess and re-offer contracts. Flexibility doesn't disappear, but it's no longer free. And it comes with that structure, that expectations. And it is a consultation, but as I said earlier, it is law, so it is coming in. It's a genuine opportunity for our sector to influence the outcome and ensure that it affects operational reality. So, as I've said several times, I urge you all to take part. The link was in the slides earlier, which you'll get a copy of. And take the opportunity to outshout these unions, because we know that they are going to input into this. So, Donal, next slide, please. And on that note, I'm going to hand over to Donal for what's happened so far with the Employment Rights Act.
Thank you very much, Claire, and hello everybody. So today I'm going to cover the Employment Rights Act. The Employment Rights Act, no underestimation to say that it's the biggest change to the employment law landscape in over a generation. I've never seen anything like it, and I've been doing employment law for a long time, so it's a massive sea change, and it's a huge shift. I think we'll all agree in the balance of power from employer to employee and worker. So just by way of a quick primer, the Employment Rights Bill received royal assent back in December 2025 and was then passed into law as the Employment Rights Act. And the Strikes and Minimum Services Level Act 2023 was repealed at around the same time. Now, for those of you who are thinking, well, that's probably not relevant to us, we don't have a trade union, I've put it there just as, for completeness, really, and to show that it's part of that shift towards a more worker-friendly, possibly unionised workplace environment. And that may become relevant, as we'll see later on in the discussion. So you'll be pleased to know that I won't be going through every single change on this roadmap in minute detail, but I've put that up to show you the sheer scale of what employers are facing, and the changes are being phased in throughout 2025 to 2027. So we're expecting lots of changes in increments. It's a handy reference tool for you, though, so good to know it exists. But really, the key message is the sheer scale of what's taking place. And my aim is by the end of today, you'll have a good idea of all of these changes as much as is possible and the practical implications for your business. So what does this mean for hospitality employers particularly? I think we can all see that hospitality is going to be massively affected by this. I think that's absolutely going to be the case. But I think what we're looking at is a huge shift towards a more worker-friendly employment law landscape, more union-friendly. There'll be a much stricter approach to enforcement, and we'll come on to the Fair Work Agency in a moment. Employers will be expected to take what you might call a much more proactive approach to employment law and making sure that their businesses are compliant than has perhaps been the case where reaction was possible. And in terms of what employers are expected to do about all of this, I think, I take the point that David and Claire have made, that it's possible to feed into consultations and the government do listen and react to those. But generally speaking, the message seems to be that employers are expected to manage any disruption, increased costs and potential liability risks. So moving on to February 2026, some more sort of trade union related changes, which I won't go into in great detail because they probably aren't directly relevant to you yet. But again, you can see that there's a number of changes aimed at making workplaces more friendly to unions, easing the path for unions to gain access to workplaces. Again, those will become more relevant as the year progresses. But moving on to the main event, what some might call the main event, which is April 2026. And April 2026, I think, brought what I would describe perhaps as a tsunami of employment law changes. Most of them were kind of expected and there was a big build up to them, but ultimately there was lots of chopping and changing, and ultimately April 2026 arrived with a bang. It really was, I think, no underestimation to say, a watershed moment. It brought in a wave of changes all at once. And although some of them might not feel immediately relevant to hospitality employers, particularly trade union reforms, they're clearly part of a bigger direction of travel. So what we're seeing is the groundwork being laid again for more union accessible environment. And so even if your business isn't directly affected, even if you don't have a union at this point, I think worth boning up on trade union law for sure, and be prepared, shall I say, for requests for union recognition, because I think at some point that may well be coming. I suspect probably in or around October, when the real union-friendly changes start to come in. I mean, you may not get them, but anecdotally, I was on a training course a little while ago, and some of the solicitors on that training course were saying that their clients are receiving increased requests, and that's even before the October changes come in. But from a hospitality perspective here, the key effects of all of these changes in April 2026 isn't just one of the changes in isolation, it's the cumulative effect of everything. So, for example, you've got the collective redundancy protective award being doubled, which I'll come on to in a moment, sort of increasing liability. New rights to day one paternity leave and unpaid parental leave. So those are huge. Sexual harassment complaints became protected whistleblowing, which again adds additional layers of legal protection, and statutory sick pay changes. But there was one change that I've highlighted in red, you'll see, and that change was the holiday pay records being kept for 6 years. So the reason I've highlighted that is because it wasn't introduced to great fanfare, it wasn't particularly expected, but April 2026 came and here it was. So I suspect that that's something that may fall below the radar for many employers. So I've mentioned it in case it hasn't crossed your desk as yet, because it's very important, and it's the sort of thing that the Fair Work Agency will be probably looking into, I should imagine. So yeah, requirement for employers to keep holiday pay records for 6 years now. So just to kind of home in on some of the ones that I think might be most relevant for you as hospitality employers, sick pay, certainly that will be a key thing. So what's happening here is, under the old rules, there were 3 waiting days, and SSP was available from day 4, and there was a lower earnings limit. Now, from the 6th of April, the waiting days are removed, meaning that SSP is payable from the first day of any sickness absence. In addition, the lower earnings limit is removed, and the pay rate is the lower of the SSP rate, or 80% of actual earnings. So I think there's a number of things potentially from a hospitality employer perspective. I think they're quite fundamental, really. So with day one rights to sick pay and more employers being drawn into eligibility, there will undoubtedly be increased costs for hospitality employers. There'll be increased workflow issues and increased importance of monitoring sickness absence levels and any emerging patterns that may require management intervention. So say, for example, if you know that a pattern is emerging of somebody taking the same day off every week, that could start to trigger potential management inquiries. But these things would have to be carefully managed, and perhaps even more so now that the disincentive to take sick pay of having that waiting period has disappeared. Equally important as the actions that employers should take, however, and should have taken by now. So if you haven't done these things, definitely worth turning your attention to them quite quickly. So updating contracts, handbooks, policies and payroll systems to reflect the fact that SSP is now a day one right, and reflecting the payment rates, or if you don't reflect those in the contract, certainly cross-referring to another document, a policy document or handbook that does. So just to give you an example of how important, some examples of how important this is, let's look at some calculations. So this is for a low earner working part-time, earning £90 a week. So before April 2026, they would have earned less than the lower earnings limit and therefore received no sick pay. But after 6th of April 2026, they're now eligible. And if you follow the calculations through, they get £72 a week SSP, or 14.40 per day. It doesn't sound like much necessarily, but if you employ a lot of people, it does start to add up once you factor in the fact that the day one, it's now a day one right. So potentially this could add up to increased liabilities if not managed carefully. And now let's have a look at example 2. So this is now an average earner, where the situation, as you would expect, gets a little bit worse in terms of cost for employers. So this is someone earning 150 average weekly earnings. So again, you follow the same calculation through, and it's £24 per day, or £120 per week. So a much more serious cost for employers, especially employers of large numbers of people. And finally, a higher earner on £400. Again, now we're looking at £123 2025, or £24 a day. Again, large liabilities potentially racking up as a result of this change. The next change of note is two new rights relating to family leave. The first is paternity leave, available from day one, mirroring other types of leave rights, and also unpaid parental leave. Both of those now available from day one. So under the old rules, you required 26 weeks service, and paternity leave couldn't be taken with shared parental leave. You had to pick one or the other, and statutory pay required 26 weeks service. From the 6th of April 2026, paternity leave and unpaid parental leave became available from day one of employment. Paternity leave can be taken on or after shared parental leave. Now, for employees and workers, that change to paternity leave is great. Of course, it adds that additional flexibility to what they can do with their parental leave. For employers, it just means a little bit more. It just means a little bit more kind of workforce planning is necessary to try and deal with the fact that people now have that additional flexibility and will probably want to use it to their full advantage. Interestingly, the government decided not to change the position in relation to statutory paternity pay. So statutory paternity pay still requires 26 weeks service. We're not quite sure why they decided to leave that alone. It had been lobbied for, but they decided to leave that alone the way it was. But it wouldn't surprise me, in all honesty, looking at the direction of travel of making workplaces much more worker, union and family friendly. I think certainly a future change to that might well fit the direction of travel that we're seeing. I'm not seeing any indication that that's happening yet, but that's me just spitballing as to what might happen. But it wouldn't surprise me. Let's put it that way. So let's watch this space for developments. And there was a new right to bereaved partners paternity leave that I thought I would put in for completeness, just to show the move towards a more family-friendly workplace. The next big change is to collective redundancy consultation. So collective redundancy consultation obligations apply where an employer proposes to dismiss 20 or more employees at one workplace location. So I'll just put a pin in that at one workplace location, because there's a small comment I want to make on that once I finish the slide. But from the 6th of April 2026, the maximum protective award for failing to inform and consult properly doubles from 90 to 180 days per affected employee. And before people think, well, we don't really we don't really tend to do mass redundancies, one thing that quite often catches employers out in these situations is it doesn't have to actually be a redundancy in the traditional sense of the word. It could be changing 20 or more employees' terms and conditions. And the reason is because the definition of redundancy in collective consultation cases, so mass cases, over 20 people at one workplace, it is a little bit wider than the usual definition of redundancy. So it can cover those situations where you're not able to get people to agree changes to terms and conditions, and therefore have to consider dismissal and re-engagement. So that's something that quite often catches employers out and leaves them open to protective awards because they haven't followed the consultation properly. But just to give you an example of what the liabilities can be if you fail to follow the process through. So let's consider the bare minimum, 20 employees on minimum wage. So 90 days, so you've got a protective award of 90 days per employee. And so the liability there for 20 employees could be 122,562. Under the new rules, of course, that doubles to 245,000. So imagine if you have a really large number of employees and you either forget that or you don't realise that collective consultation can apply in change of terms and conditions situations, or you make a mistake during collective consultation and don't follow the right process, you could have extremely large liabilities extending into the millions. Another thing just to bear in mind in these collective consultation processes, something that employers quite often miss as well, is filing the HR1 before they begin. So that needs to be filed with the DWP, and there are criminal and civil liabilities for not doing it. I don't say that to scare you, but it's just something that quite often gets missed. So, and any number of these things can lead to those problems, plus large awards. So well worth sort of revisiting that now that this change has come in. The final comment that I stuck a pin in earlier, and I just wanted to come back to, was about the one workplace location point. It's not relevant right now, but in 2027 it will be. The government's talking about getting rid of that one place workplace location requirement, and having the employee the trigger across all workplaces for multi-site employers. Now, a bit of a comfort blanket there. The figure I'm seeing bandied about is not 20, thankfully. It's in the hundreds. We're looking at maybe 500 plus, and I hope that it stays that way. But nothing is certain with the Employment Rights Act. So I think watch this space for developments, because certainly we're looking. The unions will be lobbying for a much lower figure, I'm sure. But for now, it applies that you can count your 20 employee figure at each workplace location. So the Fair Work Agency, I mentioned earlier that enforcement was going to become much more of an enforcement regime. I think this Fair Work Agency is proof of that. This is an enforcement agency, but unlike the ones that we've seen before that were introduced to look at minimum wage and living wage and things like that, this is an agency that has teeth. And certainly bigger teeth than the previous agencies I've seen. It'll be a single enforcement body. It came into being on the 7th of April, and it will enforce all of the usual suspects. So national minimum and national living wage, underpayments, holiday pay, and I would be surprised if the requirement to keep holiday records for 6 years isn't one of those things. Employment agency standards, so people who are using agencies in the hope of not having to comply with some of the new rules coming in, probably not going to get much comfort, because they're going to be looking at agencies as well, and umbrella companies are going to come under regulation. Gangmasters licensing regime, which is probably not relevant for you, but this is just an illustration of the sort of things that they're looking at. But they'll also be looking at serious labour market abuse and exploitation. So that then hooks in our 0 hours workers and people like that, ones which the government perceives are capable of being exploited, and employment tribunal penalties, enforcing those. But they'll be able to do a number of things that the previous agencies haven't. So they'll be able to enter premises and demand documentation in a way that other agencies haven't necessarily been able to do. But crucially, they'll also be able to bring tribunal proceedings on behalf of workers or employees, and this is a key point. I've not seen anything like this before. But that's even if the workers or employees concerned don't wish to do so, so they'll be able to pursue those actions anyway. So as you can see, an enforcement body with real teeth. Now it's up for debate what impact this will have on the backlogs that are in the system already, because all I can say is that there's huge tribunal backlogs at the moment, with cases trying to make their way through the system. So it's either going to be the case that a lot of the backlogs will get worse as the Fair Work Agency clogs the system up with its enforcement proceedings, or the other way around, and the Fair Work Agency is going to have a lot of difficulty trying to get its enforcement proceedings through as the backlogs stack up. We'll have to sort of wait and see how things develop on that front. But certainly an agency with teeth. So my message really, for the key message for hospitality employers, I think at this point, is this: we know what this agency will be enforcing. It's the usual suspects in terms of compliance. So time to get compliance houses in order if you haven't already, and make sure that everything's shipshape, so that you don't end up running afoul of the Fair Work Agency. Helpfully, the government has published its equality action plans. guidance. I think that's quite useful. So equality action plans became now voluntary for employers that are over 250 employees, and the government has now produced its guidance. So equality action plans will include things like the gender pay gap reporting, what support you're providing for menopause. Voluntary publication, as I say, is now allowed. It doesn't mean you have to do it, but I don't know. This is just a personal view, but my way of looking at it is, even if it's voluntary, why not do it? Because even if it can greatly enhance your reputation, showing that you've got a plan and you're dealing with sort of building an inclusive and diverse workforce that's free of discrimination. But in addition to which, so it can be reputationally enhancing, but it can also give you an action plan. It can also give you an action plan to try and root out behaviours in your organisation that you might not want, or that you definitely don't want, rather, and to build good things for the future. But it will become compulsory for larger employers, but not until 2027. But I've put in the link to the government guidance that's been issued, because I think that's quite useful to have a look at. It will give you a real good blueprint for what needs to be in these equality action plans. Sexual harassment. So probably linked to the equality action plans, but from the 6th of April 2026, sexual harassment complaints are protected whistleblowing. So that means that it's now unlawful to dismiss someone or subject them to detriment, and in simple terms that just means treat them unfairly, for raising a concern about sexual harassment, and the protection applies to workers and some self-employed contractors. Now, this is great protection for employees and workers. Of course, it gives them another layer of legal protection if they complain about sexual harassment. For employers, it adds another potential legal risk if they handle sexual harassment complaints poorly. So by now, employers should have done a number of things in relation to sexual harassment. So from October 2024, it became the law that employers have to take reasonable steps to prevent sexual harassment, and the Equality and Human Rights Commission recommended 8 steps that employers should follow. So by now, employers should have been following those 8 steps, including sort of making sure that their contracts and handbooks are up to date, making sure that there are proper risk assessments conducted, making sure that both managers and staff receive good quality training about prevention of harassment in the workplace, and engaging with your staff, setting up good, robust reporting procedures, handling complaints properly when you do get a complaint of sexual harassment, and more importantly, don't just treat a harassment complaint as you've investigated, you've given an outcome. Okay, that's the end of the matter. Use it as a learning process, so to kind of improve things for the future. So that's just a kind of brief overview of the type of things that the EHRC were recommending. But so those steps should certainly have been taken place already in readiness for this. So any employers that haven't done so should take urgent steps to correct that situation now, because, as we'll see in a little while, the law is about to toughen up once again in October 2026. So forthcoming developments in October 2026. The first one Claire will speak about. She's an absolute expert in this area, so I'll hand over to her on this point, which is tightening tipping law. There'll be further trade union changes, and this is where I suspect that hospitality employers will now start to feel the real effects of these pro-union laws coming in. The law on sexual harassment will tighten up once again. There will be a new obligation on employers not to permit harassment of their employees by third parties, and note that that's not just sexual harassment this time, that's all protected characteristics. There'll be a new power to enable regulations to say exactly what employers should be doing to prevent sexual harassment, and tribunal time limits will be extended from 3 to 6 months. So over to Claire to discuss the new tipping laws.
Yeah, thanks, Donal. As part of the Employment Rights Act, we know that then it was set out that there must be formal consultations whenever a new tipping policy or rules are introduced or materially changed. Or alternatively, there needs to be a formal review at least once every 3 years. Now, in practice, many businesses, this means a formal consultation before the end of September 2027, as many tipping policies and rules officially came into being on the 1st of January 2024, along with the tipping legislation at the time. Next slide, please, Donal. So consultation took place, the government consultation on the 1st of April, which closed earlier this year on the 1st of April. This related to the changes to the statutory code of practice. Now, we're still waiting for the response. If I was a betting woman, I don't think we are going to see the outcome of this response until after summer. I don't think they're going to push it through before the summer recess, and particularly if there may be a leadership challenge or a different prime minister. So I don't anticipate this being out and before the autumn. Might be pleasantly surprised. But along with the guidance, we are looking that there may be changes relating to non-public places of businesses, which groups of workers can and can't participate, the continued inclusion of agency workers, and also the information that we must disclose to workers. Next slide, please, Donal. So at Morkinson Smith or WMT Trunkmaster Services, we're already thinking ahead in regard to these consultations and how we can help everyone now. So doing your consultation now ahead of the 30th of September 26 will kickstart a new three-year window and won't be tied to the new formal rules coming into place. So we're operating consultations through questionnaires to your teams, and we are reaching out to our clients. And please do reach out if you're interested ahead of time and ahead of the 1st of October 2026, and get in quickly. Next slide, please, Donal, and it's back to you.
Thank you, Claire. So just coming back to October 2026, and so just perhaps I thought it'd be a good time to revisit the timeline of the expanding sexual harassment duties for employers. In October 24, we had the duty to take reasonable steps to prevent sexual harassment introduced. In April, we had the sexual harassment complaints becoming protected disclosures and equality action plans becoming voluntary. In October 2026, fast forwarding to there, we will have the duty to take all reasonable steps to prevent sexual harassment and third-party harassment reintroduced. And again, for third-party harassment, it's all protected characteristics, not just sexual harassment. And at some point, probably during 2027, I should think, provisions to prevent disclosures of sexual harassment allegations will be void, and we'll have to, the regulations are expected stipulating exactly what types of documents will be void, but we would expect that to be things like settlement agreements and NDAs. So those could well come under scrutiny and change be expected. So what do the changes mean for you as an employer? So I think it means asking yourself 8 key questions. So are your policies, procedures and contracts up to date and communicated, and more importantly communicated to staff? It's great having up-to-date documents but if if your staff don't know about them, they won't help protect you very much. Secondly, have you engaged with staff? Again, it's great to have all these policies and procedures in place and be really committed to having a non-discriminatory workforce free of harassment. But if you don't engage with your staff, you might be missing those hidden things that could help you make your action plans much more effective in stamping out the type of behaviour you don't want to see. So things like staff surveys, for example, steering groups can be really helpful in that regard. But there are others, of course, but that's just two that I've kind of thought of as good examples of what we do here. For example, that's been really effective. Have you conducted adequate risk assessments? And so I tend to, are they up to date and are they sufficiently bespoke? And so I tend to think of this as following a top-down approach. So start off with sector, then look at company, then look at departments, and then drill down to teams and then individual risks. So I think that kind of top-down approach really helps here to get a good, robust risk assessment in place. But again, don't just do them once and think, oh yeah, great, that'll do. Make them live documents. Keep on doing risk assessments as new information comes to your attention. Have your management and staff receive good quality equal opportunities training and harassment training? And is it fresh? One thing that tribunals tend to comment on a lot is if training's what they referred to in one case as stale. I think in one case an employer had tried to rely on training that was 2 or 3 years old to defend a case of racial harassment where 2 of its employees went rogue with the banter that they were using, and they tried to argue, well, the employees had received training, but the tribunal commented that the training was stale. It was too old, and even then, it was only a couple of years, maybe 2 or 3 years. So I would say, as a good benchmark, make sure that it's done annually, because the law does change rapidly. So employees and managers need to be kept abreast of it. How robust are your reporting procedures? Do employees know what to do if they experience or witness harassment? One of the things we see quite a lot is competing processes where managers will pick on the process that they think is the right one to use to look at something, but actually it's a different process when you look at it, because they've got multiple processes dealing with things. So do managers know what to do, how to investigate? Do employees know what to do if they experience or witness harassment? Do managers know how to handle complaints? And are those complaints handled well enough? So is it transparent? Do people receive outcomes? And do you deal with third-party harassment? Now, third-party harassment is incredibly interesting, actually, from a hospitality perspective, because let's face it, hospitality employers can't control everybody. You can't control what every third party might do when they come into your premises. But what you can do is take steps to protect yourself by making it clear to those third parties that the behaviour is not tolerated. So for pubs, for example, it could include barring people who behave in an unacceptable way. Well, that could be the same for any hospitality business, but particularly pubs. And one of the things that I've seen used to good effect is signs in places. I think I've seen that. I was taking a look around today as I walked from the station. I could see good ones in Coco de Mama, for example. There's some good things there saying they don't tolerate harassment of their staff. There was, again, I've seen ones in Starbucks previously and Costa. And even I think Gale's Kitchen. I think we were discussing that the other day, weren't we, Claire? That they've got some really interesting initiatives around that as well. But there are, you can't be expected to control everybody. But what you can do is make it clear that the behaviour is unacceptable to you, and then empower your staff to deal with these things if they do rear their heads, and perhaps even in some cases, obviously it won't always be right for health and safety reasons for people to intervene, but bystander training can be quite useful. It's something I've heard crop up quite a lot that hospitality employers are doing. And do you monitor, evaluate, learn and update based on experience? So do you just put things in place and think that's great, tick box, leave it there, we've done everything we need to? Or do you actually say, well, no, this is a living a living, breathing process. So as we learn new things, as things happen, as things get reported to us, we document it, discuss it, and implement it into our plans to make sure that that type of behaviour doesn't happen again. The employer that does that is in a far better position than the one that kind of has everything in place but doesn't treat it as a living learning process. So this is when I think the trade union things could hit. I could be wrong, but it looks like certainly this is when the real action starts to happen. So this is when employers have the duty to inform workers of their right to join a trade union, when unions get strengthened rights of access to workplaces, and there's new rules around unfair practices in the trade union recognition process, new rights for and protections for trade union representatives, and protections against detriments for taking lawful industrial action. So you can see that from that point on, you have to tell people that they have the right to join a union, and B, the government is making it much easier from that point for unions to access workplaces and negotiate and represent staff. So that's the point at which I think things will start to take off, if they do at all. But that's when they certainly can, and when hospitality employers should be aware that things could start to take off. Moving on to something that's happening in 2027, but I've put it in order before 2027. So from the 1st of January 2027, the qualifying period for unfair dismissal claims reduces from 2 years to 6 months, and the compensation caps are removed. So that's a problem in itself. But one huge thing that I think many employers are missing is that this law is unusual because it applies retroactively. So it doesn't mean that, okay, you start counting from the 1st of January 2027 and then when people get 6 months, they get 6 months. It doesn't work that way. Anybody who has 6 months service on that date will be immediately protected, and everybody else will be protected as soon as they get their 6 months service. So realistically, you're probably hiring staff now. You're probably kind of looking around to sort of get suitable people in place. And if you're doing that now, or if you've just got people on board, the long and the short of it is that from July, effectively, if you're employing people from that date, those people are a claims risk from the 1st of January 2027. So what does that? So I think my key message is act now. Don't wait till the 1st of January 2027 to start thinking about what you need to do. Really, what you need to be doing is getting these 4 things in order. So the first is recruitment. So how are you assessing suitability when recruiting? Are your recruiters properly trained? And is your onboarding and induction process fit for purpose? So are you setting the expectations, boundaries for performance and conduct early? Because let's face it, although I'm a lawyer, I think in terms of risk management and reacting to things when they go wrong, and okay, what legal risks are there? But ultimately, things like this, so recruiting the right people, can massively reduce your risk in and of itself. If you recruit the right people, the chances of them being someone who doesn't fit in terms of their performance and conduct reduces drastically. And in the same way, I would add a bit of a reward element to that. In that, if your package, the package that you're offering people is right, that can go a long way to reducing risk as well. So recruit the right people, reward them accordingly. Manage probation. So start getting that in order now. I would say that's going to become super important. Is your probation, so assess whether your probationary period's adequate and consistently followed. Clear objectives for new starters. Document. Make sure that everyone's trained and onboarded properly, and make sure that their performance and any other matters of concern are reviewed and raised properly. So for managers, I think give effective one-to-ones with staff and giving regular feedback is key. But not just that. Making sure that they're challenging underperformance and elements of conduct that they don't like, not just letting it go and burying their heads in the sand hoping that all will work itself out, because more often than not that's not the case. If bad patterns develop, they only get worse, not better. And do difficult conversations happen? Are managers prepared to do that, or do they prefer to kind of say nothing at all and just quietly quietly suffer in silence, hoping that it will all go away. And more importantly than all of this, and I think you'll see this in the next bit, is terminations. So I think they have to understand that there's increased litigation risk and potentially costs with the caps being removed. But a fair process becomes even more fundamental, even when someone's in probation and very early on, where employers probably have been used to a laissez-faire approach for employees that don't have 2 years service. That's very much changing, and I would say with effect from the 1st of July, that's very much changing. You would need to kind of make sure that you're following the right probationary processes and performance management to make sure that nobody who kind of happens to slip by the 1st of January then ends up with a claim automatically. But I know I kind of bang on about it with my clients, probably way too much, but document everything. Documenting every conversation that happens is almost like your policeman's notebook. It'll save your bacon and more times than you'll ever care to remember. So make sure that things are documented when they happen, and that will really stand you in good stead if someone challenges you at a tribunal. So other key changes in 2027. I'm not going to go through them all in great depth, but again, I think you can see, again, we're looking at quite a busy year for employment law. A lot of the details are being firmed up, but I think it's just quite important to know that we are expecting more changes, many of which are still subject to open consultation, so we don't know the finer details as yet, but good to know, I think, that those changes are coming in, and certainly keep on attending sessions like this. I think it would be very useful for you, and we'll attempt to keep you up to date as we can as things develop and we know more. But I just wanted to focus on a couple of interesting ones from that list. So number one, fire and rehire. So that's probably, I don't know whether any of you used fire and rehire before. It can be an incredibly useful tool, but one that got particularly bad press. Probably, I'd be surprised if a lot of you don't remember the P&O case, which kind of hit the press, which was probably, it wasn't so much fire and rehire, but fire and replace with other people. In this case, and I think it was almost a firing over video message, and then when the union staged a sit-in, the security removed them. But I think in that case they were offered large settlement agreements, which kind of effectively made things go away. But the political fallout was horrendous, and it resulted in an ACAS code about fire and rehire. Which the new government felt didn't have enough teeth, so it's kind of strengthening that up, and that's why we're here with this new potential law. So what the new law will do, it will make dismissal for refusing contractual changes automatically unfair unless a statutory exemption applies, and that statutory exemption is that the change must be genuinely required for financial stability, and a fair, transparent and genuine consultation must have been followed. So again, it's not making it impossible, but it's making it much harder. You need to be able to demonstrate that the change is required for financial stability. And that, of course, requires documentation, financial reports, and things like that. So perhaps in a way that people were able to have perfectly good rationale for making these changes before, but the underlying documentation may well come under greater scrutiny in future cases, and again, documentation is going to be key about that, and what consultation process was followed. Stepping away from the Employment Rights Act just for a moment, I just wanted to cover something that happened recently, which is very relevant to hospitality employers, which is the Equality and Human Rights Commission has issued long-awaited guidance on single-sex spaces. So many of you may remember that there was a Supreme Court case last year about the meaning, the legal definition of sex, and it was decided by the Supreme Court that sex meant biological sex. So naturally, this had a wide-ranging impact to a number of legal areas, but in particular into provision of toilet facilities and changing rooms, gyms, spas, things like that. and particularly single-sex spaces, and what employers were to do about that. So the new guidance is helpful. It's still a little bit woolly, but it's better than the last guidance that was issued. The problem with the last guidance was it was so woolly that most employers didn't really, many employers were simply applying the law as they thought it was, rather than what the guidance was saying, because it was too woolly to actually give firmer guidance. So, but this is a little bit more helpful in that single-sex spaces remain okay if justified. It must be proportionate, and the decisions must be evidence-based. So no blanket exclusion without justification, and employers must avoid leaving trans users without facilities. So I know that sounds a little bit woolly, but ultimately what the employer is expected to do is to balance privacy, dignity, safety, and inclusion. So yes, you can have single-sex facilities as long as you're able to justify them, and again, document your thought processes, and document that you're balancing the rights of all groups against each other when you make your decision, and don't blanketly exclude anybody. Think of ways that you can include everybody. For example, you could have single-sex spaces and a gender-neutral space that anyone can use. But it'll be interesting to see how employers handle this. I expect that a number of possibly a minority now, but a number of employers will still continue to grapple with the topic, depending on individual workplace pressures and opinions that may surface within specific workplace environments. But helpful to have that guidance. I would encourage everyone to have a look at it, and follow it, and conduct the exercises that it suggests when considering the matter for your own workplace. So I think over to you, Claire, for the data protection.
Yeah, final slide, everybody. You'll be pleased to know. Wow, it's gone blank. That's always good. There. So I think, this is either of going to have passed you by, or hoping that you're already all over this. But and many of you will have this in place under your kind of GDPR data protection policies. But just a reminder, by the 19th of June, organisations must have a formal process in place for handling data protection complaints. So this looks like, a document complaints handling process, providing the individuals and your employees with clear and accessible method to submit complaints, and the acknowledgement must continue to be within the 30 calendar days, and communicate the outcome promptly. So if it has passed you by, unfortunately, and you need some obviously help, there's the data protection team here at Moore Kingston Smith. So this, we do have some time for the questions. We've got about kind of 5 minutes. So we've had loads of questions in. So it's been brilliant. Thank you so much for inputting. Someone's asked, they joined late, so will the slides be sent to us? Yes, it's all being recorded, and the slides will be sent out later on this week, along with a copy of the recording that you can share. Donal, question for you. If the employees don't follow the reporting process, can we withhold sick pay? So, for example, they have to report their sickness absence at least 2 hours before their shift by calling the venue, but they don't do that and no reason is given. Where do we stand on sick pay?
Provided that it's in the contract, the contract of employment that they must follow the reporting procedures, then yes.
So they can withhold sick pay?
if it's in the contract of employment that they must follow the reporting process.
Okay, great. Let's have, can a low hour or 0 hour worker opt out of the forthcoming regulations, in particular students, Saturday staff, like to keep their flexibility? That's the general plan of the regulations. So you remember the wording, right to be offered guaranteed hours. So each employer will have to offer these workers a guaranteed hours contract, but they can obviously refuse. The issue that we've discussed earlier is about this reference period and how many times do we have to keep offering, at what length of time. So the consultation is talking about every 12 weeks having to kind of reoffer, but obviously we've got a voice here and we can say, well, that's not going to be manageable to do it every 12 weeks. Let's opt for 26 or 52. But in roundabout answer to the question is, yes, the employees can opt out, but we need to track it as employers, and we would need to reassess over a due time period. I think someone's asked, when will the consultation ends, and when will we be able to hear the outcome of the consultation? So the consultation ends mid-August, but and when will we be able to hear the outcome? So if I use the TIPS consultation as an example, so that closed on the 1st of April. We are now on the 9th of June. So that's 2 months so far. As I said, I don't anticipate the TIP consultation and the results of that to be before the autumn. So depending on when the government wants this to come into play, it's likely to be about a couple of months, I would hope, that we get chance to read all of this and hear the outcome. But as with our government, as with the Employment Rights Act, how long is a piece of string? And they could be throwing more things into the mix. So as Donal said earlier, this is a massive moving part, and obviously we will keep everybody updated. Donal, a subsequent question to your SSP answer. If it's not in the contract of employment, but it's in the sickness policy, how does that stand with withholding SSP?
Risky. Ideally, it should a little bit riskier. Ideally, it should be in the contract of employment that you can withhold that if they haven't followed the correct procedures. I suppose it's better having it in the policy than not at all. But I think the right legal answer is it should be in the contract if you want to withhold. So.
Okay, thank you. Perhaps you and I can have a discussion, and when we send out because we've had plenty of questions that we need to cover everybody on. So
yeah, sounds good.
I think we'll give more clarity on that one when we send out the FAQs. I think we've just answered one more. If an employee has set hours on a 0 hour contract, can we tell them when we want them to work, or can they still refuse work? So this again comes into the right to be offered guaranteed hours. If the employee wants to turn that down, that right, they absolutely can do. The government were, with the best will in the world, wanted to carve out some of this flexibility and stop some of the more misguided employers about abusing 0 hour workers. But we'll have some definitive answers for everybody, and we will send this out by the end of this week. So Donal, if I can have the next couple of slides. Well, just so we finish off. And the next one, Donal. Thank you. So on behalf of me and Donal, we'd like to thank you for joining us this morning, and thanks to David Sheen from UK Hospitality for joining us earlier. Really do appreciate everyone's input and insight this morning. Our next webinar will be, or scheduled webinar will be on July the 7th on generations, how to attract and engage different generations in the workplace. We've got at least 4 different generations in kind of the workplace now. So we're looking at how to engage them, how do we attract, how to retain. We're going to have a piece on different generations treat tax, and how we can help, and also the different generations and changing consumer habits around low and no alcohol drinks, the impact of weight loss jabs, and the rise in protein. So, if you're an HR person, about the employees, or your finance, or you're an operator and want to know how these changing habits change your food and drink offering, then do sign up. I'm going to be joined by Lee Collins, our tax partner at Moore Kingston Smith, Karen Turton from Purple Story, and Joe Lynch from Cam Media. So please do sign up. So thank you all for joining, and we hope to see you soon. Thank you very much.